Hi, everybody. I'm Chris Godsick, and this is Chasing Evil, a bonus mini episode for you. For those of you that have just listened to the 2 episodes on the Anthony Ojeda case, I've heard from many of you kind of wondering about this charge of manslaughter in the second and why that was important. And for those of you not from New York, this broad sweeping reform that happened in New York in 2020 called bail reform. And we're going to just kind of go into that in a little bit more detail because I think it's actually quite interesting. And to do that, we are honored to have Lee Kindlon, who is the district attorney of Albany County, New York. Thank you very much. And currently in the United States Marine Corps Reserves.
That's
Thank
correct.
you for your service, sir.
Of course.
And Caroline Murray, who is a former prosecutor for Albany County, and she was the prosecutor on the Anthony Ojeda case. So, Lee, start us with what were the conditions that led to something that was so sweeping and, I mean, I'll just use the word insane bail reform, at least for a short time.
Sure. So, and I've been in criminal practice for 20 years. I've been the DA since January of 25, but before that, I was a defense attorney in upstate New York. So, prior to bail reform, judges could set bail on anything, from the lowest level misdemeanor all the way up to murder. And so you'd have cash bail for people stealing a pack of gum from a local bodega. And you just got used to the fact that there were abuses in the system, that suddenly people became penalized because they didn't have the money to bail out. They'd lose their job, they'd lose their home, they'd lose their family, etc. The state legislature came around to reforming all of these things. But I think now, in hindsight, we can all agree that perhaps the reforms kind of went a little too far. Where suddenly they didn't set, you could not set as a court bail on, I think, most, if not all, misdemeanors and then non-violent felonies, with a few kind of real particular exceptions. And when that came into effect, there was, and again, with hindsight, probably just a free-for-all all over the state. And I think that's where this case really highlighted some of the problems with bail reform. Now, since the reforms, there have been reforms to the reforms and reforms to those reforms that have drawn a much closer net around what exactly is what's called non-qualifying for bail. That is, people can just get let go. So now, today in 2026, the rules are much different and much more reasonable. But yeah, for a time, it was a real weird landscape for criminal defendants.
And I'm going to use the laws that came into effect, the initial reform, because it so blows my mind as just a member of the public that I'm going to mention a couple of the things that you could be arrested for every single day of the week. And Lee, Caroline, tell me if I'm mistaken when this went into effect. You could be arrested for this every single day of the week, and the judges did not have the discretion to either keep you in jail or set bail. You were not going to be going to jail, and you were not going to be putting up any collateral for bail. And among those that fit this description is, of course, manslaughter in the second, and we'll get to that in a minute. But killing a police work dog or a police work horse. You did not go to jail. You did not pay bail. Somebody thought this was a nonviolent crime. Okay? Promoting an obscene sexual performance by a child, possessing obscene sexual performance by a child, or promoting a sexual performance by a child. Essentially, I look at this, and correct me if I'm wrong, this is child porn. And child porn was considered, yes, it's nonviolent.
And
Maybe.
it depends on the way it's charged. It could be charged as sexually motivated, and in that instance, it would then become a qualifying offense. So there are certain nuances
Right.
involved.
And 230.34, most sex trafficking, and which includes the promoting prostitution with in the first victim of less than 13. Somebody in
Mm-hmm.
this sweeping reform thought that it was okay that this was a nonviolent offense, and it did not require law enforcement to protect the public. Because if you weren't going to go to jail and you weren't going to have to set bail or pay a bail, you're going to just keep repeating the behavior. I mean, why not? Until your trial comes up in X number of years. So it kind of, without being political, because to me it has nothing to do with politics, it's insane. And to take the discretion away from the judges, I think, was also, again, as Leah said, seems like a real overcorrection, and they did change it, but not on this day. On January 1, 2020, this is what came into effect. And at the time, tell us, Caroline, how did this affect the Anthony Ojeda case? And why is apparently manslaughter in the second is looked at differently in New York State than it is in other states of the Union? And it's looked at as a nonviolent offense. And in this case, we had somebody who, I don't even think it was known at the time he was charged, but was responsible for the death of a 6-week-old by the use of methamphetamine.
So manslaughter in the second degree, it has different sentencing. So an indeterminate versus determinate sentencing. It is an indeterminate sentencing crime. In New York State, it falls on, reckless behavior versus that intentional behavior. Anthony Ojeda was originally charged with the manslaughter in the second degree because at that time we didn't have toxicology back yet. Police didn't know at that point in time enough specifics to make a determination other than what they felt comfortable with having enough to charge, which was the manslaughter in the second degree.
So you didn't know that baby Eli had necessarily OD'd on methamphetamine?
There had been interviews at that point in time where both Anthony Ojeda and Neil Garzone had been making some admissions, but there was nothing back from the toxicology yet to confirm that information. So we were really waiting to see what the toxicology would show. And then when that came back, it's still, making a determination. Well, what do we present to a grand jury, and what do we ultimately make a determination to charge? Because nobody, I don't think, thought he intentionally killed Eli, that was his intent, was to cause his death. We do ultimately, as the indictment charged, believe that he provided methamphetamine to Eli. That methamphetamine was the cause of his death, and he had a duty of care to a vulnerable child under his care to get immediate medical attention, and he did not get Eli that immediate medical attention, and that caused the death of Eli. And that depraved indifference standard is the theory under which we were moving forward on a murder in the second degree indictment.
Can you just define that a little bit further, depraved indifference?
So depraved indifference has a very specific definition in New York state law, and it basically is a wanton disregard for another human's life. So we would have to prove reckless conduct that created a grave risk of death under circumstances showing utter disregard for human life. So it's a really high standard and burden of proof, but we believed that we had that in this case.
Right.
See, Caroline still got it. She still knows these things by heart. I'm so impressed. So, Chris, it's like the standard, examples are like you set off a bomb in in a subway, or you open fire into a crowd. Like the stuff you're doing, it's not necessarily intentional to kill person A, but you're so depraved, it's so kind of whacked out that you show an utter disregard for human life. So Caroline's right. It is a really high standard, and it's not charged as much. But it is a great way to charge somebody with murder if you can't necessarily prove, A intended to kill B. So it's a different theory of murder, but it still works.
And
And it's really
intent is the real differentiating factor, is whether someone intended to do it.
intended to cause the death. Yeah. And
Right.
Yeah.
in New York State, it's interesting. Case law has, in terms of trying to figure out what the best thing to charge, I really, at the time, looked into the history in case law, and depraved indifference has changed based on case law throughout the years, where it used to be, that depraved conduct could have been directed on a one-on-one situation. New York's now veered away from that, and it's more of a, a whole, not just direct at one person, but shooting a gun recklessly into a crowded room, or throwing a
Mm-hmm.
bomb into a crowded room, where if there are exceptions, such as in this case, that one-on-one the reckless behavior directed on a one-on-one basis still exists in a case where there is a duty to a vulnerable individual. So in this
Mm-hmm.
case,
Mm-hmm.
that duty existed to Eli as his guardian, a vulnerable 6-week-old baby.
Okay. And do we have any idea why New York looks at manslaughter in the second differently than other states?
It's I've only been an attorney for 20 some odd years, but it's always been that way. I mean, it's just the way the legislature has defined manslaughter in the second degree. Manslaughter in the first degree is a B violent, right? But manslaughter in the second degree is a C non-violent. So, as Caroline was saying, the maximum possible punishment on a C non-violent felony like manslaughter in the second degree is what's called an indeterminate term, where you can get as little as 5 years and as many as 15 years. So you get sentenced to 5 to 15, and then the Department of Corrections decides when to let you out in that time frame.
Mm-hmm.
But it's just that is the way Man 2 has been defined in New York for as long as I can remember.
Interesting. Okay. Thank you. And Caroline, were you surprised that he fled to Mexico? I know that when we did the podcast, the guys from Cahoes and the marshals were very emotional about this case.
Mm-hmm.
And got emotional, kind of choked up on the podcast. How did you feel about this case?
I mean, it's any case involving a homicide is one that is going to stay with you. But, when it involves children, those are the kinds of cases that really you have an emotional investment that, will stay with you for forever. And I think that the fact that Ojeda, left the country, could any of us foresee that happening in any specific case? No, it could happen in any case. It could not happen in any case. It's one of those things where, we try our best to see, and argue within the ability that, and I'm sorry, I'm realizing as I'm talking that I'm saying we, and I'm not a prosecutor anymore. So
That disclaimer has been made.
So, but as someone who is trying to stay within, the lines of the law at the time that you're handling a case, and make sure that you're making arguments that are within your right to make. And, with bail, what arguments can you make to ensure that someone's going to return to court when they're directed? Because that is the standard. And whether you agree with it, whether you don't agree with it, our job at that time, my job as a prosecutor at that time, is following the law and, making sure that I'm making arguments that are within the law. And it's really hard when you see that, with a change in law that was as extreme as the one that there was, this is an outcome where there's a defendant who has caused the death of a 6-week-old child is now fleeing the country and potentially not going to be held accountable for his crime. That's a really difficult thing to see. And the hard work of Cahos and the state police and the marshals and getting him brought back to the United States and held accountable is really one of the highlights of a career.
Excellent, thanks. And Lee, just to put a point on this, at the moment, you feel like the bail reform has been reformed, and at this point, you are at a reasonable environment. You work in a reasonable environment.
We do, and so I think my office has been, aggressive in pushing back to get people who might flee, not necessarily locked up, but under pretty heavy pretrial release conditions. So we have, within the bounds of the law, done everything we can to, fight for either detention or high bail, or electronic monitoring is now a big thing. If there's a reason to have the bail reexamined, we immediately file motions. So we're really trying to play within the boundaries. But the governor and the legislature and everybody kind of realized that, we overdid it, and right. we've come back.
Okay.
But and I will say, and I just want to point this out because we just had an updated stat this morning I got from my chief investigator. Thanks to, and Caroline gave them a shout out, so I'm going to do so as well. Thanks to the marshals and the state police and the sheriffs and everybody, law enforcement, my office, the investigators who work there. Basically, based on the pattern, based on the efforts and the outcome of the Ojeda case, my office has been able to apprehend in the past year 31 fugitives on warrants. So the model that you're touting and that Caroline was a part of, to bring Ojeda to justice is now something that my office has brought forward to go out and find guys who have fled for years sometimes and bring them to justice in Albany County. So the work that's been done on this case has proven to be the model in what we bring forward. So this case really, has set a very high standard that I'm trying to match all the time.
Okay. Well, I wanted to get some clarity, and I thank you both for adding that detail and giving everybody a little bit of a clearer picture as to what the state of affairs was at the time. Okay, well, thank you very much, Lee, Caroline, and Albany County. Appreciate that.
All right. Thanks, Chris.